House Judiciary Committee this Wednesday morning, February 25th. And most of this morning, we're going to be spending on testimony on H 613. And we will start with a walkthrough with Legislative Council. So thank you for being here. And we're down some members in the committee. The snow is keeping some southern members from getting here. I mean, they're going to get here, but a little late. And we have another person on vacation. So we have.
Send this all to you.
Yeah, Kenny's
also
on.
as
Okay, if you could unmute that person.
I can't. They can get them somehow.
Oh, okay, good. Over to you, Michelle.
Good morning.
Morning.
So for the record, Michelle Childs, Office of Legislative Counsel. And we're going to do a walkthrough of H 613 as introduced. And I'll just want to give you a little warning here. So I don't usually work on law enforcement. It's usually in the third portfolio, but Hillary's carrying a big load already as a newbie to the team. And so I'm doing some of these law enforcement bills, but we have some questions that are probably better answered by some of the witnesses. And so we're going to start looking at the language. And just a few things to note here. So we're working in, there's two titles in Title 13, two chapters in Title 13 having to do with victims. So there's the victim statute and there's the, chapter, and there's the crime victims chapter. Why they're separate, I don't know. It predates me. But the crime victim statute deals with restitution, victims' compensation, things like that. The victims chapter deals primarily with rights of victims. And that's like where you see the statute with regard to victim advocates that are embedded within state's attorney's offices. That's where you see the kind of rights that victims have in terms of notification of certain proceedings, the ability to provide a victim impact statement. So I just want to kind of note that those two different statutes, because they do have different definitions that are contained in there with respect to who is considered a victim. And one of the things that you'll see in here is you'll see oftentimes this new language added about someone who is the victim of an officer-involved shooting. And that's because there are circumstances where they would already be included in the definition of victim, but only if it's a homicide and declared a homicide. So I think probably some of the testimony and things you'll talk about is there may be an officer-involved shooting of a person with who is experiencing a mental health crisis, and but that wasn't determined to be a homicide, right? So let's start the language. So we'll start, and I assume everybody's got the same version as I do.
That's introduced.
Right. I know sometimes that I don't know, they show up sometimes we get a different pagination. But if we're looking at page 2, section 1. So this is the definitions in the victims chapter. So it pertains to victims' rights, has the victim advocate stuff in it, notification. And you'll see the first changes on the definition of victim, which is subdivision 4, line 16. And you'll see right now, it's a person who sustains physical, emotional, or financial injury or death as a direct result of the commission or attempted commission of a crime, right? So the officer-involved shooting of a person experiencing a mental health crisis may not be the crime. Could be, but may not be. And it's adding on lines 18 and 19, or an officer-involved shooting of an individual experiencing a mental health crisis. And you'll note at the top of page 3, under existing language, it says, it also includes the family members of a minor or person who's been found to be incompetent or a homicide victim. Next is subdivision 8. And definition of officer-involved shooting means a law enforcement officer who discharges a firearm in the performance of the officer's duty. And I will just say I wasn't the original drafter on this, so I might just, as you motor along with the bill, whatever, I might just kind of offer some little clarification as to some language, but it's not necessary to kind of point things out at this juncture. So section 2, now we're working in the definition section as it pertains to the crime victims chapter, right? So that's like victim compensation program and restitution. So if you look, first changes on page 4, subdivision 5, the definition of pecuniary loss, because victims can apply and receive some compensation to make up for certain losses that they have sustained, not things like emotional harm, pain and suffering, things like that. But you see the definition of pecuniary losses, and these are things that insurance isn't otherwise going to be covering. And so you see the addition of pecuniary loss means in the case of the victim, the amount of medical or medically related expenses, loss of wages, and the new language, property damage, and cleanup of biological or hazardous materials or fluids. And so again, something that you're going to see throughout the bill is addressing the situation. I believe you heard from some witnesses about a month ago or so around the issue of the state doesn't have a particular response to assist families when they're with cleanup of a location if there's been an officer involved shooting. Page 5, subdivision 7, definition of victim. So right there, again, it's just adding. So like on the first line, the subdivision 7A, a person who sustains injury or death as a direct result of the commission or attempted commission of a crime, or an officer involved shooting of an individual experiencing a mental health crisis. And again, it's kind of brought through to address those situations and put it on par with a victim who is who has been harmed by a crime. It would be kind of putting on par in terms of their ability to receive compensation. Rest of the changes are just technical. You'll see at the top of page 7, there's also the same definition of officer involved shooting. Section 3 is on the application for compensation. And so I know you've got Jen Pullman, who's going to be testifying to you, and you may have questions about how the victim compensation program works. And I'll leave that to her to kind of fill you in on the details and how that works logistically. But here's how you apply. So victim or a dependent of a victim shall, upon application, be eligible for compensation under the following circumstances. One is that a law enforcement officer has filed a report concluding that a crime was committed. So just keeping in mind around like compensation and restitution. Restitution is something that is ordered if there's been an adjudication of guilt and someone's been convicted and the court can order restitution. So my understanding with regard to victims' compensation is that you have to be able to show that a crime was committed, but you don't necessarily have to wait that whole thing for everything to play out with regard to the defendant. So that's adding an officer involved shooting of an individual experiencing a mental health crisis on subdivision 1, as well as subdivision 2. The rest.
Question from Jack.
Yeah, thank you. Actually, I think Tom was first. He had his hand up for a while.
Oh, I didn't see.
I'll yield to the member from Sheldon.
Back to definitions really quickly. Seeing as this is all about somebody, an individual experiencing a mental health crisis, do we actually have a standard for what that is, a definition?
There is not a definition.
What's that?
There is not a definition in here.
I just think that's important if that's what this is going to be dealing with. Some sort of standard,
Definition of what? Say again, Tom. Sorry.
an individual experiencing a mental health.
Yeah, that's exactly where I was going. Are you all set, Tom? So that was one of my questions in terms of how a mental health crisis is defined, Michelle. Actually, my questions really begin on let's see, where were we? I guess page 2. And it's not necessarily page 2, it's really throughout the bill, but the question that I come back to is if the officer is in fear of his or her life and it's a justified shooting, I feel like that isn't really captured here. Like, I think there needs to be some carve outs and exemptions that if officers are acting within the bounds of the law, and I mean, the case that we heard testimony on, although we didn't have a bill at the time to know what to associate that testimony to, while a very tragic instance, and any loss of life is tragic, there's a lot more, I think, that we will hear about in terms of testimony about that specific incident where the officers were called in by the judge and they were serving, I don't know if they were serving a warrant or if they were intervening on behalf of the courts, and they felt in fear, reasonably felt in fear of their life. And so I just feel like that there has to be some kind of protection here for law enforcement.
So it's really just a policy choice for this committee. Where it's being used is around in these sections is with regard to access to services for victims. And so for either someone who was involved in the shooting or for a family member. So when we're talking about adding that in these sections, it's related to the types of services that they would get. It's not a judgment on whether or not the use of force was valid or not valid.
Right.
We're going to get to an amendment with on here that I'll show you that does amend the statute on use of force. But but again, policy decision for y'all.
Yeah, it just seems that there's a bit of subjective language here. I mean, one of my concerns always for whether it's this piece of legislation or other pieces of legislation that come from this committee is whether there is opportunity for it to be abused and for frivolous lawsuits litigated on behalf of, well, I don't care if it's law enforcement or any other third party. So I mean, we can keep going through the walkthrough, but I think that was just something that stuck out. And I also think it's rather the language on page 5, line 14, subsection B on intervener. I'm just thinking if someone is injured in the course of a lawful law enforcement operation, is that an intervener and they put themselves in harm's way? They try to prevent an arrest. They try to prevent law enforcement from serving a warrant. That to me seems like an intervener. I don't know if that's defined either in statute.
Can you point me to the language that you're?
Page 5, line 14, subsection B, an intervener. I don't see that defined throughout the bill.
I can look to see whether, I mean, I think that would just be a plain language interpretation of that. I don't know whether or not any case law looked at the extent of that.
Yeah, it just seems like in typically with bills that come before this committee, we don't really leave things to plain language. There are pretty copious amounts of definitions that we leverage. So I would love to see one for that.
Well, I think when you hear from Jen Coleman, she can probably address the issue of when people apply to the Victims Compensation Board, how they are interpreting that existing provision of law, because that's not changed here. So she can probably address how they are, and they do have policies with regard to how they, assess applications.
That's fine. That's fine. I'm all set, Chair.
Okay, next is on page 9, section 4. And this is adding a new statute on victim guardians. So you have the existing statute. I think you guys are pretty familiar with victim advocates who are working in state's attorney's offices and providing a number of services that are identified by statute for them to provide to victims. And this is a little different, and this is creating the position of victim guardian. They would be within the Center for Crime Victim Services, as opposed to right now, victim advocates are at the state's attorney's office. Victim guardians are to be independent of any criminal investigation or prosecution in order to provide conflict-free advocacy for victims. They're to coordinate with the victim advocates and any other advocacy organizations. And continuing on page 10, they're to perform duties in accordance with the job description as identified by the center, including providing assistance to family members of a person who is a victim of an officer-involved shooting of an individual experiencing a mental health crisis. Such assistance shall include coordinating with the family to make arrangements for cleanup of the scene and property damage that occurred at the scene and any disposition of human remains. At the request of the family, payment of expenses can be made directly from the center to the vendors, and the family does not need to make a request for direct payment and can apply to the Victims Compensation Program as an alternative for those.
Let me ask a question.
Sure.
Just to put up section A, shall be independent of any criminal investigation. Is that really possible if Center for Crime Victim Services is a state agency and crime, or the victim advocates currently have an obligation under Brady to pass anything information on to the prosecutors and on to the defense counsel? Wouldn't that be the same requirement for victim guardians? You can't just write out the independence, if they're a state.
I think that those are questions that you probably want to check with the witnesses about in terms of the scope. Like there's not much here in terms of identifying the duties and scope and how they are to be independent. So
Save that for some of the witnesses.
Okay. So section 5 is requiring 15 hours of mental health crisis training in a program approved by the Criminal Justice Council and the Vermont Department of Health. So there's a date of January of 2028 that all existing law enforcement officers would need to receive that training in order to maintain their certification. Page 11, and then there's a continuing education component in subsection B, so every 2 years. One question I had was whether or not it's got to be like another 15 hours or not, or if there's something different there. And then subsection C is that the Vermont Police Academy is to employ a mental health crisis trainer for the sole purpose of training Vermont law enforcement and related practitioners on issues related to mental health. I will note that when I get to the end, you'll see there are positions created for the victim guardians, but there is not a specific carve out or appropriation for this particular position.
Right, and we'll be talking to Christopher Zach.
The question of whether this is going to JFO for financial impact to DPS.
We haven't asked yet.
Okay, but that would probably have to happen, right?
If there's money that continues in it, yeah.
Yeah. And I guess another question is, the program has to be approved by BCJC or EMH. Do we have a sense of preference of who would provide this training?
I think that's a question for Chris.
Okay.
Yeah.
Next, still on page 11 is section 6, and this is your statute Title 20 having to do with standards for law enforcement use of force. And we'll see, so you have the definitions. There's no change to the definition. So we're going to move on to page 12. And there you have your lead in for subsection B for use of force. And there are there's some guidance in there with regard to how do you assess whether a decision by a law enforcement officer to use force was objectively reasonable. And you'll see on page 13, subdivision 5. So you already currently in statute have language around when a law enforcement officer knows that a subject's conduct is the result of a mental condition, mental impairment, developmental disability, physical limitation, language barrier, or drug or alcohol impairment, or other factor that is beyond the subject's control, the officer is to take into account in determining the amount of force appropriate to use on the subject, if any. And then it adds these new kind of criteria for like assessing whether or not the use of force was reasonable. And so you'll see starting on line 13, unless impractical, law enforcement officer encounters a subject experiencing the conditions, shall employ de-escalating tactics prior to using any force, and then it lists a variety of de-escalation techniques.
What's your question?
Yeah, go ahead, Jack.
Line 17, imminent threat of death. I assume that's the victim's imminent threat of death. Committing suicide.
I think it could be anybody.
So either the officer, so if the officer fears for their life, they can enter, or if they feel that the person inside the dwelling is going to take their own life. That would justify force of entry.
I would say yes, but I think you should talk, those are questions
Yeah.
really for the people who are working with the policies currently about how they interpret this.
I just think we'd want to clarify that in the language.
Page 14, section 7. So here you have positions and appropriations. So as I mentioned earlier, there's 2 new classified positions for victim guardians, and those are created within the Center for Crime Victim Services. Fully loaded, that comes to $230,000 for the 2 victim guardians. Money comes from the general fund, starting in fiscal year 27. I did get that number from JFO looking at kind of what the numbers are for victim advocates. So that does track. And then on page 15, subdivision 2, you'll see there's an additional $20,000 for the purpose of paying expenses related to an officer-involved shooting of an individual experiencing a mental health crisis. And so that would be cleanup of any biological or hazardous materials at the scene of the shooting, repairs to the property. So if there's been, a door's been broken in, things like that, and then also cover disposition of remains. And it has an effective date of July 1st.
So 2 questions. $20,000, is that a single instance of cleanup?
It doesn't indicate that.
So we're just saying $20,000 should cover all of these.
I'm sure people can debate what the number should be.
Yeah.
I think there's just kind of that amount of money, and then it would be up to the Center for Crime Victim Services in determining how much to pay of that 20.
It just seems arbitrary to me. The next thing is on the effective date. We wouldn't have retroactive application of the law for any cases that have already happened, even if a lawsuit has not been filed on behalf of the deceased against the state of Vermont.
Well, I don't think nothing about this has to do with people filing a civil suit against the state.
Right.
In terms of,
Or seeking damages, right? There's some kind of compensation.
but that's just an application that's just qualifying them as a victim of crime who can access and make application
Right.
for.
But the point
for
that I'm
service.
getting at is that it wouldn't be retroactive to cases that have already happened and been litigated.
No,
there's
I mean,
some
in the general rule is that laws are prospective unless indicated otherwise. I mean, I think if you want to look at, certain dates or things like that, we could do that, but generally it's prospective.
Because we ran into something similar with the water runoff case against the farmers last year, is that we weren't allowing retroactive legislation. So I want to make sure that we have a protective clause in there.
All right, any other questions for Ellen? Not seeing any, we will next go to Chris Dolores. Chris, if you can. Thank you. Thanks for traveling up from Rutland.
You're welcome. What wanted to add, the roads were fine. It was the knuckleheads drive.
Yeah.
I have no written testimony. Sorry, Nate. Introduction. My name is Christopher Loris. I'm from Rutland, Vermont. I do apologize to the committee and to Nate for not having written testimony. But the amount, I will provide written testimony to the bill as it is currently drafted. And I'll speak to those real quick, and then I'll, Mr. Chair, I'll ask the representative Maida ask me to tell a story. That's what I'm going to do. So, name is Christopher Loris, Rutland, Vermont. First disclaimers, I am an appointee to the E91 board. I am not speaking wearing that hat at all. I am also a subcontractor working with Gwen Zakoff and Megan Novak with Garnet Government Relations as consultants to the State Department of Public Safety on the Public Safety Enhancement Team. That's been rolled out in a few communities around the state, and I'm not wearing that. So 613 specifically, I'm just going to have a peek at a couple notes, and I do apologize that I've got to do that. Thank you. Appreciate that. Those are the disclaimers. One thing I will say regarding 613, I didn't write down which provisions accommodate for a more robust victims advocate positions within Vermont Center of Crime Victim Services. Yes, absolutely, positively. Crank that up. I was very fortunate that my family and I were able to work with Katie Brighton when she worked for the Department of Public Safety through the Vermont State Police as a victims advocate, gold standard. And I would say that I know she's moved on from DPS, but that's the type of individual you need to clone to fit into these positions for victims advocates. People who take survivors' needs into account rather than statutes, policies, rules, regulations. And that is my lived experience. Another piece I think needs to be accommodated for in this bill is to accommodate wellness for the officers who've been in officer-involved shootings. That is an issue that this body has taken up a couple times over the last few years with no funding. And don't forget that piece of the equation, that there's somebody on the other end of that weapon who does not want to exercise that authority they've been given for lethal force. So please, as you accommodate for survivors like me and my family, please also accommodate for the wellness of the officers involved. Regarding the training for Criminal Justice Council, another disclaimer, I served 3 years on the Vermont Criminal Justice Council as a gubernatorial appointee from 2020 to 2023. Have the highest regard for the VCJC as an organization, and I trust them to do the right thing to accommodate for the proper training for law enforcement officers in de-escalation and working with interacting with individuals who are in mental health crisis. And I will say on the record also, this may get me in trouble, but at this point I don't care anymore. I do rely on the professionalism, integrity, thoughtfulness of the VCJC. With this bill, I would say DMH is uniquely unqualified as an organization to create standards for training for officers. There are subject matter experts all over the country that the VCJC can engage with that would be supported by victims, survivors, victims advocates. But I think that given my years of experience tangentially working in the criminal justice world with the Department of Mental Health, I will say that they may want to be left out of this conversation to create new policies because of what I've seen from people within DMH, their acrimonious relationship with the Department of Public Safety and with officers in general. And I have a problem with ceding authority to DMH to come up with that type of thing. So that's me being the angry witness right now. And I'll leave that be. So on to the story. So I'm here as a survivor. Give you all a quick story, whether or not all you know it. It's okay. Good refresh for those who do. Back in 2019, my son Christopher was a victim, qualified that way, of an officer-involved shooting. He had suffered through 8 years of relapse and recovery from the opioid crisis, along with his cousin Nicholas, the most codependent relationship I've ever seen in my life. Loved each other, hated each other, supported each other, undermined one another. Same age, two cousins. And my son Christopher murdered my nephew Nicholas after the wee hours of an October night in 2019. Christopher drove to the Rutland City Police Department, and with his assault weapon that I didn't know he had, because I was able in the previous 2 weeks to secure his handgun that I knew he had. I did not know he had a long gun. He took shots from the car to the front of the Rutland City Police Department and drove away slowly. A couple hours later, hour and a half, I don't know the timing actually. I've never read one article about it. The officers found him in his cousin Nicholas's girlfriend's car. And some type of chase, don't know what level, ensued. Christopher got out of that car with his long gun. I don't know if he fired shots or not at the police. I imagine he did. But it was a good shot. The 4 officers that were there, who are friends, were friends, are friends, will be friends. Had to do, as I said earlier, what no law enforcement officer has to do. It was a good shot, righteous shot. And those 4 guys will have to deal with that going forward. The officers involved and any counselors, therapists I spoke to, victims advocates, it's clear that it was suicide by cop. And the officers had no choice as he exited that vehicle with the long gun, likely fired. So that's the story of Christopher. But this bill is about victims and survivors. Yes, he was in a mental health crisis. His brain broke. You can't kill your cousin without your brain breaking. You can't go shoot up a police station without your brain breaking. You can't approach 4 officers after a chase without knowing what you're doing and looking to kill yourself, frankly. I need to reestablish where I'm going here, folks. I apologize. So that morning, I received a call from his girlfriend saying she was worried. Chris was gone. His weapon was gone. I said, what weapon? She told me what weapon. I went to the PD looking for the chief. Chief was unavailable. I was told, hey, you can catch the chief over at the scene. I went to the scene. Officers at the time in that morning thought it was my nephew, thought it was Christopher's cousin who was in that car. Then I said, okay, 5'9", 165, or 5'11", 220. And I was told the latter. And I'm like, Chief, so I need to go to the hospital. He said, yes. And I asked, was it a fatal? And he said, yes. Went and grabbed my wife, pulled the other 2 Christopher's younger brothers out of school, and went and grabbed Justin, Christopher's Irish twin. 1 month a year, they're the same age. And Justin, as with the rest of the family, a survivor of this incident. He did engage with Katie Brayton, but unlike the rest of us in the family, he felt he could handle it, and he didn't engage with counselor, with therapist, didn't unpack his crap. And over the course of the next few years, accommodated with the isolation of COVID, his brain too devolved. He felt guilt for not having been there for his brother and his cousin, which is false. And unlike me, who stayed away from media of all types, he consumed it. And Justin's brain eventually broke. He continued to have very deep feelings of guilt about it. Recognized the ghoulish nature of conversations online and the media, and ultimately couldn't take it anymore and took his own life. Prior to that, he had told me, "Hey, Dad, I'm not going to do what Chris did." I assumed he was talking about ending his life. He wasn't. He was talking about going out the way Chris did and not losing his own life or taking his own life. So, for those of you in the Judiciary Committee who've got law enforcement creds, no fun clearing 2 cases when they're your adult kids. I cleared one with Christopher by going to the scene, identified him at the hospital, and cleared my second son's investigation because I found him. So, what does that mean for 613? Whether or not this bill survives, I'm offering up an amendment, simple amendment, and talk to Representative Byrd about it in the cafeteria, as well as Representative Kenny, can't pronounce his last name.
No, I can't. Okay.
And willing to talk to the other 2 members that aren't here today. But, oh, look,
Thanks.
sorry, guys. So what I'm here to ask, plead, and I thought about this for a couple of years, talked to Katie Brayton about it prior, talked to Jen Pullman about it yesterday morning, that as part of the bill to support survivors, please consider tightening up public records with regards to dash cam, body cam footage for officer-involved shootings. Sometimes they need to be out there. I think, George Floyd, Emmett Till, moms and dads who want to say, "Look what they did to my boy," allow that to continue to be for those footage, dash cam, body cam. But for survivors who don't want it out there, where there is no public interest, please accommodate for that. Because there will be other people like Chris's brother Justy, left-handed, dyslexic, colorblind, artist, and the kindest individual who I've ever met. And I said that way back when he was 12 years old. And he never faltered from being that kindest person I ever knew. And I wonder, had things been different, had he not known that all that was out there? Thank you. I don't know. But he should have been given a chance not to have to deal with the traumas, the guilt, should have been able to deal with the issues you need to deal with exclusive of a ghoulish video that the media thought needed to be out there for all the wrong reasons. Yellow journalism grew out of sensationalism, detail, and I'll say it again, ghoulish thoughts over 120 years ago. And until 20, 25 years ago, yellow journalism was able to do their thing without footage. And there's no reason why this body cannot, should not accommodate for victims, survivors who do not want that footage out there. For the families that do, you can accommodate for that too. For the families that don't, for the love of God, just disallow public records to include footage in officer-involved shootings or other instances from dash cams or body cams. And I'm going to channel one more issue that's still working its way through, I don't know, through the courts. But a 19-year-old girl who wanted desperately to be nothing but a law enforcement officer in the city of Rutland died during a chase. That's all I'm going to, not going to editorialize that. But her family should not have to worry about opening up a computer or opening up a paper and knowing that the last moments of their daughter's life is going to pop up on a video screen during an officer-involved chase and watch their daughter die. So I can get a little more emotional about others than I can about myself, obviously. But that's a simple amendment. And if any of y'all want me to accommodate for members of the press down in the cafeteria to have a heart-to-heart with any member of the press that would say otherwise, Daddy-o, I'm ready to go talk to him. And I think I'll talk sense into him. See what else I got here, guys. That's all I got. Sorry for the downer. I know this is a hard one. And any questions at all before I give you a parting shot? Anybody?
Any questions though?
Okay.
No question. I guess just a statement. I mean, everybody in Rutland County lived it with you on some level. Maybe not at the same level as you did, but
Oh, you all did.
we were still there with you.
You did. You were.
Because your former job as mayor, your family's, well-known businesses in Rutland through the years. So, I don't know if we can do this. We can write an amendment and we can put it in the bill, but I want to know if we can even do this constitutionally, if we can lock up certain public records and make other certain public records public. It needs to be the hopes we can do it. It really is.
I get you.
But if it comes down to, and I'm gonna guess it probably has gone through a couple other people's minds, it may be unconstitutional to lock up those records. Whether it's a good idea or not.
There are exemptions for many things within
Oh,
this.
I'm sure there is. But what I'm saying is we can't just do it. We're gonna have to, we're gonna take testimony and of course, and find out if we can do. Like I said, we can do it.
Understood.
But
No,
time will tell if we can leave it in bill.
Yeah. No, thank you, Mr. Representative Byrd. I get that.
Yeah.
No, I served my 2 years in purgatory in this building from during the 05-06 session. So I know what you're up against. I get it. And I know there are other considerations and there are always other considerations. But I think this one's more or less a common sense one. And constitutionality requires someone to drop paper to challenge. I welcome that fight with the press if that's where they decide to go. Anything else, Mr. Chairman?
No, I really appreciate that. But Coach, unmute yourself. You have a question?
Hi, Chris. I really
I
want.
hear him a little
Can't quite
bit.
hear you.
Volume or?
Is that,
We're not hearing you. I don't know if your mic's working.
is that better?
Oh,
Uh,
we barely
no.
hear you.
Oh, wow. Got the volume all the way up.
You can hear him, just, yeah.
Yeah, but it's quiet.
Yeah.
Is that better?
Oh, it's better.
Okay, cranked it up all the way.
There you go.
There we go.
There you go.
There we go.
I cranked you up all the way on our end too.
Thanks. Chris, thank you so much. You know, and my heart's with you, my friend. But I think, I have that same feeling as Representative Burdett. We'll do what we can, and your testimony rings true on so many different levels. So we'll just see what we can do, and we'll have to address those constitutional issues with other witnesses as we move forward with the bill. So I just needed to say that, and thanks again, Chris.
I appreciate that, Coach. Thank you so much. And I don't want to leave you guys with a downer, so I will say that and the world turned upside down, our family, broadly, the entire Loris clan and extended family members in a weird way, including the guy that replaced me as Mayor, Dave Allaire, because we shared Nicholas as a nephew. So just want to say that our family is strong, stronger than it's ever been. We're really lucky that we're a strong family, including my 92-year-old mom, old barn cat, who lost her 3 oldest grandsons, old hill farmer from Mount Holly, who is still with it, still engaged. And if I were to call her right now and put her on speakerphone and ask her to speak with Representative Burdett so he could explain to her why he's endorsing a knucklehead like Tom Donahue for mayor in the city of Rutland, I think that would be enjoyable to watch.
I don't know if that was appropriate for this. Or not.
Just looking to bring you guys back some levity. I know this was hard for you to listen to. It was hard for me to speak to, and you've got hard work to do. So get your brains back out of emotion and into rational thought, please.
Appreciate you being in. Thank you very much, Chris.
Thank you, guys.
So we'll turn to Jennifer Pullman, who is joining us by Zoom. Jennifer, thank you for being available this morning.
Yes, and thank you, committee. I wish I could be there in person, but I'm trying to figure out that work-life balance that people say that I'm supposed to do, and my kids are on break. First, I want to, for the record, Jennifer Pullman, Executive Director of Vermont Center for Crime Victim Services. I want to thank Mr. Loris first for speaking and for sharing his experience. And as he alluded to, he and I have spoken, and I support the considerations he's thinking about. And obviously that's probably for a different, it might be for further conversation, but would want to support that absolutely and explore where that can go. As of turning to 613, I'm not quite sure where to start. So I'm going to start by saying I really appreciate the intention, and I understand what has brought this issue forward. I certainly get the desire to increase supports for those experiencing mental health crises and how they may intersect with law enforcement response. So I appreciate the focus on looking at that issue. I listened to the heartbreaking testimony from the Garvey family, and it's hard enough to deal with the grief that one experiences with a tragic loss, never mind having to come upon a crime scene that one has to deal with on their own. That being said, the center opposes the majority of the bill. And I don't say that lightly. I'm really disappointed to have to say this, because we weren't, even though we seem to be the most popular entity in this bill, we were not consulted at all. And so I view this bill as a missed opportunity to have actually had a constructive conversation with stakeholders that could have potentially gotten us to a different place. Because what this bill proposes would frankly bankrupt our program, and goes way outside the bounds of what is feasible. Our concerns start on page 2. And so I will be an additional downer, but not in the same way as Mr. Loris was. This is just going to be that rational piece. Starting on page 2, we are proposing, or it's proposed to have a change to the definition of victim under 5301 subsection 4 in Title 13. That piece speaks to so many different ways in which victims are referred to, are supposed to be provided with rights. And frankly, when I think about the state's attorney's victim advocates caseload, impacts them directly. And so I'm not sure, since we're thinking about these cases in terms of ones that would not already be crimes, what that does to that definition in terms of their workload and in terms of other ways that we cross-reference this definition. This is a solid definition that is in case law. It's cited in Title 28, Title 33. So I really think before we go and change this fundamental definition to victim, we need to really look more deeply at that. As to page 3, I'm concerned, especially because it so directly impacts work that we would be expected to do, about the definition of officer-involved shooting. It says in the course of discharges their firearm in the performance of their duties, discharges. There's no statement about what the injury is. If there's an injury, it just says discharges in the course of their duties. So again, that broadens for me right now, and as I read it, broadens what are we looking at in terms of, what the impact on victim advocates is, but also when I get to the compensation program, further muddies the waters. So that is unclear to me. And then we get to the compensation program, starting at the bottom of page 3. But really more turning to page 4. The change to the definition of pecuniary loss starting on lines 12 and 13 is seriously problematic. First, if there's probable cause, we are covering crime scene cleanup. Property damage, we do not cover unless it's related to a safety issue. So replacement of locks, replacement of if a domestic violence survivor is fleeing and her windshield is smashed, we'll cover that, but we don't cover property damage. So that would, in and of itself, blow up the fund. As you know, we have a $509,000 deficit projected, and we have never covered property damage, just straight out.
Before you go, Barbara has a question.
So Jen, can you clarify, in the case of the Garvey family, why was cleanup something that would be covered? Like, is the definitions sort of preclude people who were killed by law enforcement?
No, we only cover crimes. So if there's no probable cause, there was a crime, then we would not cover that. So there's no probable cause at this time that a crime was committed. So opening up in that way would mean well, I'm going to get to that, but no, it wasn't that we
Okay.
decided that it wasn't coverable. It was that right now we don't have an affidavit of probable cause. So the definition change to pecuniary loss would apply to all of our cases.
Let me back up for just once. I apologize. I just want to clarify something on this. So an officer involved shooting, if months later, it's determined that it was manslaughter or there was, an affidavit for probable cause, at that point, would the fund be able to reimburse somebody for the cost of cleanup, or is that already passed?
No, we would be able to do that.
Okay.
We keep cases open forever. So if there were to be, who knows what the conclusion of this investigation may be. But if there was a finding of probable cause, we could reimburse it.
Yeah, and I'm not talking about any particular investigation. I'm not talking about the current one, or just if there is an investigation that leads to probable cause. Okay, thank you. No, keep on.
We do work with state police especially for a while on some cases when there's an ongoing investigation, and the minute that they say there's probable cause, then we can step in. So that's pursuant to state law and also federal regulations. But so in terms of changing that definition, again, that would in and of itself blow the fund up, to be quite honest. Turning to
Janet would do what?
the fund would be over. We would have no money. There would be no
That's what I
program.
thought you said.
We can't cover all property damage. So that is in and of itself a problem. And again, it probably would have been helpful if we were involved and we could have avoided that. But at this point, to completely change it, no other state and federal regulations do not cover property damage in the way that this would propose. With respect to, let's see. I'm going to turn now to the definition of victim on page 5, lines 12 through 13 and 18 through 19. As mentioned, we're unclear as to what the definition or the meaning of officer involved shooting is, because in this proposed definition, it could be somebody that it speaks to discharge of a firearm, and we don't know what that means. So we would need some clarity on that. We would also need clarity as to the definition of a mental health crisis. We have 3 people who process all the claims in the state, and this would be asking a tremendous amount of them to try and decipher what is meant as the bill is currently written. Again, if there is PC or probable cause, we can cover these expenses, but this bill is opening the door to a whole other level of actions that we don't normally cover if the definitions are nebulous. I do want to turn to lines 17 through 19 on page 5. Currently, subsection C exists to be able to allow us to provide support to surviving family members in a homicide.
So before you go ahead, I apologize. If you could back up, go ahead, Zach.
Thank you, Chair. Hi, Jen. So before we go into subsection C, I'm wondering if you could comment on subsection B, which is a question that I asked Legislative Council about intervener. And I'm curious if the network has a working definition or if you have an interpretation of what that means, or if you think, like other terms in this bill, it deserves further clarification.
Thank you very much. I did have that as something to address at the end, but I'll speak to it now. And
Thank
just
you.
a reminder, we're not the network, we're the center.
Sorry, center.
But we did go through this, I think, last year because we were concerned that the definition of intervener was overbroad. And we made a change so that it would require physical injury and also included protected professionals. Because what we were getting claims for was somebody who would call 911. I'm thinking of the case, the Red Square homicide in Burlington. People were present, they called 911. they were seeking coverage as an intervener. That again was not what the original intent was, but we did do an exhaustive search and we asked nationally, from our other programs, what does this mean? And there's no actual definition of intervener in the same way. So it's not a good answer, but it's the one that we researched, and I believe Eric Fitzpatrick helped us with this, and we couldn't find anything at the time. This was in the miscellaneous judiciary bill.
Thank you very much, Jen, and apologies for the mix-up. I'm still in budget mode, so going in between witnesses.
Aren't we all?
I know. Thank you.
So back to subsection C. This would again change the structure that we have in a significant way, because the intent was to support surviving family members of a homicide. And again, looking back to the definition of, or unclear definition of what an officer involved shooting is, that would require us to provide support to all family members in this regard. So under victims' compensation, every family member in a homicide has a right to their own claim. That's a claim of up to $10,000. Not knowing what the implications of that definition are, that's a real challenge for our program. So generally, we have the same concerns with that definition as it impacts the rest of our statutes. I will just turn to the positions that begin on page 9.
Before you go ahead, Zach, go ahead.
Thanks, Chair. Ken, I just wanted to double click on subsection C and kind of the scope and how broad that definition is. So it'd be your interpretation that extending beyond, so any other survivor who may suffer severe emotional harm, and I'm on line 20, could that be friends of the victim? Could be acquaintances, relationships, domestic partners?
Domestic partners are included. There's a specific definition for those. As far as other survivor, we take those to the board. Generally, what comes under other survivor is, for example, a stepchild who might petition for their own claim, and we always take those to the board. So we don't make those determinations on our own. If you don't fit into these categories, then we bring those cases to the board, and the board, which is appointed by the governor, they make that final decision. So it's a little bit more, again, case by case. Sometimes, we have people bringing forward a claim because they're extremely close and they have a documented relationship with the person. So we're just not saying, well, just everybody. We are taking those considerations to the board.
Okay, so it seems like there's more of a checks and balances as far as that goes in terms of, just being litigious for the sake of, getting the $10,000.
No, we're very careful with our fund.
Well, no, and I know you are. I know you're very good stewards of resources, but I just want to make sure that there's some kind of protection there.
Yes.
So I assume you're moving on to victim guardians.
That was the plan, but I'm happy to take any questions.
So I guess I wanted to get your feedback on a general concept which may or may not involve the victims' compensation fund. So one of the things I'm concerned about and would like to explore, if there is something that can be done, is where there's an officer involved shooting, whether it was justified or not, that there is the scene of the shooting, and whether there seems to be a gap. If it's a homicide and you have probable cause right off the bat, you're there to help individuals clean up the situation, clean up the scene. But if it's an officer involved shooting, that cleanup is going to occur way in advance of a determination of if there is probable cause or not. Just going right to it, but my view is that if there's been an officer involved shooting, the state, and I'll say more broadly, the state should be responsible for cleaning up the scene. just like if there's an auto accident, the state actually cleans up the scene there if there's a crash and there's fatalities. And that's not necessarily, though, in my mind, would be coming from the victims' compensation fund because it's kind of a separate gap that I think is there. And I think there should be some responsibility. Am I right that that's not necessarily, I mean, it wouldn't necessarily fit into the victims' compensation fund. It might be an other avenue that can be explored.
It's almost like you read my mind, because this has been an ongoing issue for us, even with the Victims' Compensation Fund. Because the fund is utilized for crime scene cleanup. It's not unusual for there to be a victim's compensation claim that maxes out to clean up after the law enforcement response. Which means that there are no other dollars available to support medical expenses, mental health expenses. We've had claims, and this goes to a question Representative Harvey had mentioned earlier about that $20,000. We've had cleanup go to $30,000 for one particular scene. And we had to ask for a special clearance from the board to go over the cap, but that was all that that victim had for their claim, because there'd been a particular response that was not taken on as the responsibility of the state. And so the victim bore those costs. So I don't think it's a, I think it's a, I wouldn't say it's a gap per se. I think it's an issue, because we shouldn't be using the compensation fund. That victim has $10,000. Not in all cases is it a crime scene cleanup that would warrant the victim to have to pay for it, and the state should bear the burden. So I think it's more of an issue than a gap.
Yeah, and I guess I'm seeing where the gap is possibly is with respect to officer-involved shootings. And I shouldn't call it a crime scene because it's not necessarily a crime scene. The scene of that incident, that it's not, it seems to be a separate obligation to me if there's going to be some period of time before we really find out if there was a crime, if there was probable cause. And most often it is not. I mean, I trust our law enforcement officers, historically have had their use of force justified. So it's not even, it's looking at any kind of officer involved shooting. And it's a little bit separate than if it's not officer involved. I understand that's a separate issue, but it's also an issue, what you just explained, as far as in those instances, it is a crime scene cleanup, and presumably that can be done with funds from the restitution fund. And that's a separate challenge. I understand that that's a separate challenge. I guess it just seems a little bit, those are two separate issues, it seems to me.
No, I see them as parallel and adjacent, but I do agree with you that that is a gap that should be addressed.
Yeah,
But
and most of the times with those officer-involved shootings, you're not going to get to the point where there's probable cause, because most of the time they are justified. So it would never really be in the realm of something that would be paid by the restitution fund. So I think it is somewhat separate. In any event, I just want to put that idea out there for you, and we'll ask other witnesses about it as well.
I do agree. I do agree. I don't think any family member should have to walk into what has been described. And I do think that the state bears that burden. I do agree.
Okay, on to victim guardians.
I like the idea that there's money available. This is not a request again from us. I don't understand the positions, and I have a lot of concern. Some of which has been mentioned a little bit earlier. To say that somebody has independent authority doesn't give them independent authority. I was a part of the development of the Office of Child, Youth and Family Advocate. And there was a lot of work that went into establishing what the powers and authority of that agency is. And I'm concerned about just creating another position that potentially has promise, but really can't deliver, because this office has no powers. This position would have no powers. There are HIPAA issues. I really don't understand the purpose and what this position could actually do. So we do not support these positions.
Would the positions be placed in the center?
Apparently, I don't know. This was
Well,
not-
then my next question is, did anybody contact you and ask you about adding any positions to the center?
We have not been contacted about any of this bill at all.
Okay.
So
My fear is, and I've seen it done before, in this bill is obviously got a lot of money attached to it. My fear is that positions like that are gonna be left in here, but there's gonna be no funding for it. Wouldn't be the first time.
well, we don't have the capacity to take on any unfunded positions.
Right.
Certainly don't want to take on a position that again presents itself as being able to provide options for victims when it really won't be able to do anything. I coordinate, I take calls from victims and survivors all the time, and I do my best. And I don't understand how this position would be any different than what me and my staff are already trying to do.
Right, and the way I've seen it happen, and I'm sure you've seen similar things happen, is like a committee like ours will put the money in there, then it'll go to appropriations and they'll leave the bill intact and pull the money.
I have other ideas for the money, but I'm not asking for money today. These positions are ones that I don't understand, and I don't want to give victims yet one more person. Now you have a guardian and you had an advocate and you had this person. If the person can't deliver and there's no actual promise of anything that could be done in a realistic way through the language as I see it with this position.
So I asked Michelle earlier, maybe you're not able to opine on this, but and you mentioned it a little bit as far as independence of victim advocates. It's my understanding that they still have an obligation to pass on to prosecutors information that might be relevant under the Brady standard that would have to be turned over to defense counsel. So my understanding is victim advocates really aren't independent of the criminal investigation. They have to turn over information. And is that, am I correct in that understanding?
Yes, and simply by housing somebody with us who would be, I guess, a guardian, we still are a state agency and we still are subject to public records requests. So there's nothing inherent in what this person, again, as I understand it in the language that's here, could do that would protect that information either.
Right, you'd still have to pass over exculpatory or inculpatory information to the prosecutor, then to defense counsel. Okay, thank you.
I got a question for Jim.
Yeah.
So, officer involved shooting. Turns out totally justified. The way I look at it at that point, the officer is the victim. Would they qualify for any of your services? I know the police departments have mental health, services for themselves. I don't know if it's state, if it's, for the per department thing, but would they qualify for any of your services? Because at that point, to me, they're a victim.
We have, so this is a little bit complicated.
That was my guess.
In terms of first responders, they absolutely are eligible if there's an injury. And if there's a separate affidavit that they're a victim of crime, yes, absolutely. If they're an intervener, yes. For example,
A physical injury?
it's physical, but that's broad. We have provided coverage, for example, first responder who provided CPR and some support for someone who was bleeding. And they were worried about exposure to disease, and we did provide coverage and support for that person. That's a case that comes to mind. So there are different examples in terms of how we've supported first responders as interveners. So we can do it in two ways, but those are the only two ways we can do that. So either an affidavit that they're a victim, or intervening and experiencing injury. But again, as with all things, if a case comes before us, and I can think about where your wheels are turning, Representative Burdick, if somebody suffered emotional injury and they were to apply, that's still something we can take to the board. So it's not completely foreclosed.
Thank you.
Karen.
Thanks, Jen, for being here. And maybe you're getting to this, so I apologize if I'm pushing forward. But I'm curious, I really appreciate your perspective on bills like this with the voice of victims and survivors. And so it's helpful to hear that you're like, okay, this is not the fit, but it's bringing up likely an important conversation. And so I'm curious if there are any kind of viable threads of this bill that we should continue to work with, whether it's this session or a future session. Like, what are the pieces of this that we should be looking at? Because I'm picking up that maybe this is not the vehicle, but how do we keep it going?
Well, I do think that the training components are important to look at. I think it's a great first step. And so those pieces I would want to keep. I do think, again, it's really an important conversation, and it's unfortunate it didn't happen before this was introduced, because I do think it was a missed opportunity. I'm happy to engage with people because I do see this as a very big gap. I don't think families should be put in this position. And so I want to be a part of the solution. It's just unfortunate that it left the horse left the barn a little too soon. And so if there's a way to continue the conversation and that feels like something that you want to direct, I would like to be involved in that.
Thank you.
Hey, did you want to weigh in on any of the additional sections of the bill?
I think I'm good at this point. Y'all have heard a bunch from me. And again, I'm sorry that I don't have anything more constructive to offer, other than the fact that I do want to be a part of the conversation, and it's unfortunate that we were not a part.
Okay, one more question, Zach.
One last one for you, Jen. On the trainings, do you have a sense of who you think would be the appropriate agency or department to conduct those? Not to put you on the spot. If you, I mean, we can talk offline if you'd like.
I do think that some of what Mr. Loris did bring up as far as
Concerns with the MH.
I do think it's worth having somebody a little bit more objective and neutral. I always feel like when we put on trainings that people respond more to somebody who's doesn't have a piece of the pie and is a little bit outside of that space. And I do like that direction.
I think that makes a lot of sense. And I also just want to express my disappointment too that you weren't consulted in this bill. I think that's a shame and a missed opportunity for the sponsors and whoever brought this.
All right, so we're going to turn to training and use of force next with our next two witnesses, but I think we probably need a 10-minute break, so we'll start at